If Nadhim Zahawi, the Minister in question, were to waive the usual statutory consultation rules, would you then be able to disclose the settlement agreement and the background to it?
So taxpayers can consent for HMRC to share details of their tax affairs with other people, and that's normal, for example, when they have an agent. However, it would still not be normal for HMRC to publicly comment on someone's tax affairs, even if they had said that it was okay for us to do so. But we have in the past, for example, in relation to Google, given evidence to this committee, and we were able to give more expansive evidence than usual because we had that company's consent. But our requirement not to disclose information publicly kind of sits whether a taxpayer is relaxed about it or not relaxed about it.
Okay, but if they were to give you explicit permission to talk about it in order to clarify matters, would you do that?
Normally, if a taxpayer gives us consent to speak to someone about their tax affairs, then that's what we would do. And for example, when MPs correspond with us about their constituents, there's an implied consent on the part of the constituent for us to share information. And within the terms of that implied consent, we would therefore disclose.
So in the case in question, if the Minister in question, Mr Zahawi, was to give permission, for example, for you to disclose to this committee or the Treasury Select Committee, would you do that?
I would not. It would not be normal for me to account to this committee for a person's tax affairs, but if there are general issues about how we manage tax, and I've got the ability to be disclosive, then that's obviously something I would take advantage of.
And with the various inquiries taking place, if you're given permission by the individual concerned, will you then provide information to those inquiries to the ethics advisor at number 10?
So if we are asked by the independent advisor on ministerial interests to help with the inquiry, we will do so in any way we possibly can. And if any person involved gives their consent for us to share information, then that is something that we.
And if they don't give consent to share information, do you have a responsibility to flag any issues of concern?
So as you know, we are subject to a duty of confidentiality, and that is something that applies equally to all taxpayers and in all circumstances. We have got some discretion to share information if that's necessary for our functions, and we've got some transparency about how we do that, but it is very limited.
Okay, and so on that point, just it might be helpful that you do sometimes disclose a sort of a status for taxpayers. Edward Troop, formerly of HMRC, has explained the red, amber, green approach that we believe takes place with honours. Can you just explain for the record how that works with HMRC providing information if someone is put forward for an honour or for elevation to a peerage?
Yes, so we have a memorandum of understanding with the Honours Secretariat in Cabinet Office, and that is published on gov.uk, and that explains the basis on which HMRC will share limited information with the Secretariat to assist with the administration of the honours process. The information we give is limited. It's based on what risk a nominee might pose to the integrity of the honours system because of their tax affairs, and broadly speaking we would give a rating of low, medium or high, or green, amber or red, and that would be the extent of the information that we would provide, and then it's up to the people who make decisions about honours to take that into account together with any other information they have.
Who makes those judgments in HMRC? Is that you directly, or do you have a special team that does that?
There are a group of senior officials in HMRC who routinely look at those. I have in the past certainly been one of those people, and I suspect Penny may well have been as well. But there are a group of mainly senior compliance officials who make those judgments. We have published some indicative criteria for how we arrive at that. So those are not exhaustive, but they give people an idea of the kinds of behaviours that would cause us to rank someone low, medium or high.
Thank you very much. And so that's for the honours system and elevation to the peerage. What about when people are appointed ministers? Do you have a similar approach for that?
So obviously decisions about appointing people as a minister are made by the Prime Minister. The Prime Minister can receive advice from Cabinet Office. It's not something that HMRC is responsible for. I can't comment on what those processes are. They are Cabinet Office processes. There is no published or formal memorandum of understanding, for example, in relation to that.
Okay, but if the Cabinet Office asks you for information along the lines of what you provide the honours system, would you be required to do that, or would the taxpayer confidentiality be an issue there for you?
So taxpayer confidentiality rules apply to everyone in all circumstances. So, if we are asked in any situation, we would have to consider whether it's within our legal powers to do so. In relation to the honours, we have concluded that it is within our legal powers to make limited disclosures, but that we would have to look at that on a case-by-case basis.
Okay, so if the Cabinet Office, Cabinet Secretary or the Prime Minister requested information, would you be able to provide a similar?
So my approach would be to be as helpful as I possibly can within the constraints of my legal powers.
Okay. Others will come to that, I think. But if a prominent politician or someone in a key public role, such as Chancellor of the Exchequer, says something about their tax affairs which you know to be categorically false, would you make a statement at all to correct that?
I think as a general rule, our duty of confidentiality would mean that if a taxpayer made a public statement about their affairs which we felt we did not agree with, that would not be a matter that we would correct. But again, we would look at things on a case-by-case basis and decide whether, in that particular case, the issue was such that it was within our functions to disclose information. But as a general rule, our default is that we don't disclose. And it can be a source of frustration for HMRC because people will brief the press or perhaps brief MPs about their tax affairs. We will sometimes feel it's not the full story, but we have to deal with it on the basis of their disclosure because we're not in a position to disclose further information.
Okay. Would you contact the individual direct if they were of a significant public position to advise them that it was perhaps unwise to say something that was not factually correct?
I mean, as a general matter, it would depend. I mean, if we felt that a taxpayer had misunderstood their position and that they needed to understand that in order to administer their tax affairs, then perhaps we would. But if someone, if people are entitled to say what they wish to say to friends or family or press, whatever, it's not my responsibility to sort of police their behaviour in that way.
Okay. If they're in a significant position, such as Chancellor of the Exchequer, do you feel you have any responsibility to advise the Cabinet Office or the Prime Minister's Office or Number 10 generally about any behaviour that might be conflicting with their responsibilities of oversight with HMRC?
So I think that's something we would have to look at on a case-by-case basis within our functions. There's no general rule. Obviously, responsibility for complying with the Ministerial Code and for declaring any issues in relation to the Ministerial Code is a matter for ministers. It's not a matter for me as an official to police or enforce compliance with a code. But on each case, we would have to consider whether in this particular case it was within our legal functions to make a disclosure, but proactive disclosure of information about taxpayers would be an extremely rare matter, I think, for HMRC to be involved in.
Okay, well, I think we're dealing with quite a rare matter. On that point, I'll move over to Sarah Olney MP.
Thank you very much, Chair. Mr Harrott, I was just wondering, what does HMRC understand, or what does it mean to imply when it uses the word carelessness, that someone has been careless with their tax return, and what should the general public understand by the use of that term?
Again, I'm not commenting on any particular person's affairs, but carelessness is a concept in tax law. It can be relevant to how many back years that we can assess, and it can be relevant to whether someone is liable to a penalty, and if so, what penalty they would be liable to for an error in their tax affairs. There are no penalties for innocent errors in your tax affairs. So if you take reasonable care but nevertheless make a mistake, whilst you will be liable for the tax and for interest if it's paid late, you would not be liable for a penalty. But if your error was as a result of carelessness, then legislation says that a penalty could apply in those circumstances. So those are the two occasions when HMRC would consider whether non-compliance was careless, when we need to understand what back years we can assess and when we need to understand whether there is a penalty due.
Okay, so carelessness could mean in your case that just to come back to what you were saying, it was an innocent mistake. So a not innocent mistake, is that
So,
when carelessness would be
I use the term innocent. I don't think that's the statutory language. The statutory language is despite taking reasonable care. So if you get your tax wrong, despite having taken reasonable care with it, then there's no question of us charging you a penalty. You would, of course, still have to pay the tax. But if you have been careless in your tax affairs and as a result of that carelessness have made a mistake, then you could be liable to a penalty for any understatement of tax that you've made.
Thank you.
Thank you very much. Dan Carden.
Thank you, Chair. Is there any situation where you would see it in the public interest the need to disclose taxpayer information?
There are some specific situations laid out in legislation where it is within our functions to disclose it. So, for example, in court proceedings, we would do that despite the fact that they are in public. That is within our functions to disclose information there. So there are some limited circumstances, and legislation does provide for that.
Does HMRC offer bespoke advice to government ministers on financial matters or their own tax affairs?
Well, HMRC,
how would that operate if a government minister was seeking that advice?
HMRC does not give people tax advice. That's for them to get for themselves. We do, of course, give all taxpayers guidance about what they need to do in order to comply with tax law and with what action we would take if they did certain things, and that would apply equally to ministers as to other taxpayers. But we don't offer a tax advice service to ministers just as we wouldn't to general taxpayers.
You told us a little bit about the process around the honours system. I've been told that when ministerial appointments are made, the person being appointed is often asked, are their tax affairs in order? Is there no contact between HMRC and the Cabinet Office or Number 10 ahead of ministerial appointments?
So that the process for the decision whether to appoint someone is made by the Prime Minister. Obviously, the process for advising the Prime Minister is a matter for the Cabinet Office, including whether they would, what declarations they may ask potential ministers to make, and whether they would get any information around that. So that's not a matter that I can comment on.
So, for instance, in the last 2 years, there hasn't been any occasion where you've had to flag concerns over a ministerial appointment?
So again, HMRC does not flag concerns. These are not decisions for HMRC, and it's not for HMRC to make any judgments. If we were approached for information, we would look at whether we can provide that information within our legal powers, and we would do whatever we can to assist, but not if it meant disclosing information that we don't have the legal power to do.
So are you routinely contacted by the Cabinet Office or Number 10 ahead of ministerial appointments?
No, not in my experience. That is, the process for appointing ministers is handled in Cabinet Office. They have got their own processes for that, which you would need to, I'm not really privy to them or responsible for them, but we do not. There's no part of that involves routine engagement with HMRC or routine disclosure of information by HMRC.
Just when you're elected as a councillor, you have to sign something to say that you're content for your council tax records and so on to be anything you might owe the council financially to be checked. So you sign a waiver. Do you think that you have the legal? Is that possible under the rules now? Or would the law need to be changed for that to happen? Any changes that would need to take place for you to be able to provide information if a minister was required to sign a waiver as a routine matter?
So that whether that is something that should be done is a matter for Cabinet Office. It's not a matter for HMRC.
But I was asking about the technical. What would you need? What powers would you need in order to do that?
So, as we discussed earlier, taxpayers can consent for us to share information with other people, and that can sometimes make it easier to manage people's tax affairs and make our lives easier as well. That's generally professional advisors or MPs, for example, or voluntary organisations that are helping people with their tax affairs. But whether that was the case here would be a matter for Cabinet Office.
Okay, but if the Cabinet Office just said from now on every minister needs to sign a waiver to say that we can approach HMRC to get a rating on your tax, a flag on any tax issues, that would be possible. Once, if the Cabinet Office just decided ministers had to do it, you could then do that.
If they wanted to look into doing that, that's something obviously that we could look into. But I can't answer what the outcome of that would be.
Well, I think it sounds like we may be moving in that direction. Okay, thank you very much. Mr. Peter Grant, MP.
Thanks, Chair. Mr. Hara, I want to come back to the question of carelessness. What's the difference between carelessness and negligence?
I'm not sure. They're different words, I suspect, largely for the same behaviour. I'm using statutory language. The language in the statute is taking care and taking reasonable care, and that is that's the test that we apply. So we look at whether you've made a mistake despite taking reasonable care, or whether you have failed to take reasonable care in your tax affairs.
You mentioned earlier on you might go back and look at several years of records. Is that with a view to seeing whether the same careless mistake had been made repeatedly, or is it about seeing whether it had been drawn to the taxpayer's attention and they'd done nothing about it? Would that count as carelessness, or would it be something else?
As a safeguard for taxpayers, there are statutory limits on the number of back years that HMRC can assess, and that is a protection for taxpayers because it means they can have certainty that their previous tax affairs are in order, and the number of years that we can go back and assess depends on the nature of the error that the taxpayer made in their affairs. So if they made a mistake despite taking reasonable care, then I think it's 4 years that we can go back, but we can't go back beyond that. On the other hand, if they failed to take reasonable care, we can go back longer than that, and if they made a deliberate error, we can go back up to 20 years, I believe. So it actually affects the safeguard for taxpayers about the certainty of their tax affairs.
Thanks. You seem to be saying that the use of the word careless in this context is maybe a bit more severe than certainly I would use it. I would think a careless mistake in my tax return is if I add a zero or miss out a zero or transpose the numbers when I'm time for them in. That kind of mistake. You seem to be suggesting that within the context of tax law, carelessness could go a bit further than that. Would carelessness, is it possible for it only to be carelessness if it gets to the point where a professional advisor that was complicit in that carelessness could face professional conduct consequences?
First of all, the degree of care that we expect someone to take will vary depending on the taxpayer and their capabilities and their circumstances. So there's no rule that applies across the board. We will take account of the person's capabilities and whether it was a reasonable course of conduct, for example, for them to do something themselves, or whether they should have sought professional advice. The more complex your tax affairs are, the more that we would the higher the standard, I guess, that we would expect you to follow. As a general rule, if a taxpayer seeks professional advice from a properly, qualified and competent tax professional and acts on that advice, that is often is the way that they could demonstrate that they took reasonable care with their tax affairs. But obviously, if tax advisors themselves are incompetent or have misconduct in their affairs, then that's a separate matter.
Would it be reasonable to expect that somebody who was fit to hold the public office that meant that you guys were all accountable to them, as Chancellor of the Exchequer, that person would have a higher expectation as to their competence to fill in their own tax?
I think we're straying into talking about a particular person, which I'm not going to do. But as I've said, the level of care that we expect someone to take is not flat across all taxpayers. It depends on, it will vary according to your capabilities and according to the nature of your tax affairs and, for example, how complex they are, what degree of care we would think it is reasonable to expect someone to take. And we're not the arbiters of that. All of our decisions that rest on carelessness, whether it is to assess a back year or whether it is to charge a penalty, are appealable. So ultimately the arbiters of what is taking reasonable care in any circumstance are the courts, not HMRC.
Are you able to tell us approximately what percentage of taxpayers would have a penalty of 30% or above applied each year? Does 30% mean it's quite a serious matter, or is it a trivial thing that you slap 30% notices on everybody?
So we have published sort of guidance about the loading of penalties in cases. So that is available for everyone to see, and that is standard, and we apply it across all cases. But I don't have information for what number of cases we would have every year. I mean, in compliance cases, in any compliance case where there has been an error, our compliance officers would look at whether there has been behaviour that means that error is such that a penalty should be charged, and the decisions about whether or not to charge a penalty are subject to internal governance in our compliance group, which the level of that governance varies depending on the nature of the case, mainly the size of the case.
But you don't routinely publish. I know a lot of regulators publish statistics for prosecutions, for example. Do you routinely publish statistics that say this is how many taxpayers had a penalty of this degree, this is how many had a minor penalty? You don't publish that?
No, I don't believe we do.
I think we publish aggregate numbers in the annual report and accounts under the Tax Assurance Commissioner's report. I'm not sure from recollection that it's broken down by behaviour. I think it's, but we could check that.
Okay.
And you mentioned the Tax Assurance Commissioner as something that the committee's had a keen interest in. Is this sort of settlement something that commissioners have a look at?
Well, again, I suspect you're referring to a particular case. So we have published our code of governance for how we govern decisions in disputes with taxpayers, and when the Tax Assurance Commissioner and 2 other commissioners will make the decision, and all cases are subject to that governance without exception.
Okay, and then the speed of which decisions are made. I mean, we've looked before on this committee at obviously some big companies where they've got complex tax affairs. They have taken a decade sometimes to have an investigation. The case that you can't talk about today, but seemed to happen quite quickly. It's difficult to tell. Is there a 2-track system for deciding on cases? What makes something speed up to the extent that we seem that this case may have been faster than some cases we've seen?
So, we would treat all taxpayers in the same way in terms of determining their liability. We want to settle any case as quickly as we possibly can, and many compliance cases are opened and closed very quickly, but that depends on the nature of the matter under dispute, under inquiry, the nature of the investigation work that we need to do to establish facts, what the attitude of the taxpayer is towards cooperating with us, or perhaps, because all taxpayers have a right to disagree with us and to take their matters to tribunal. Very often, particularly in technical disputes, there will be other cases with the same dispute, and sometimes cases will wait behind a lead case to be determined. So there are a whole variety of different factors, but our aim certainly is to settle cases as quickly as we can, and we do internally target ourselves on what the average elapsed time should be for cases of different types.
And we know from previous work on this committee that there are a team that help support higher earners, the big wealthier corporations and individuals with their tax affairs, of relationship managers. Does that speed things up if you've got a relationship manager?
So the 2,000 largest businesses in the UK have a customer compliance manager, so do the wealthiest people. That is because of the nature of the risks that they pose to tax revenues and to compliance, and therefore the need for them to be man-marked in effect. And part of the role of the customer compliance manager is to make sure that we are very familiar with the person's or the company's tax affairs and the nature of the risks they pose, and to foster a cooperative relationship with them so that we can deal with their tax affairs as quickly as possible, and often know about risks that are approaching before they crystallise, and start engaging with them straight away. So yes, it is part of the aim of having customer compliance managers that tax affairs are dealt with as quickly as possible. If you look back at 2006, when we reviewed large business taxation and introduced this method of dealing with compliance, one of the key issues then was the extreme length of time it took to resolve disputes, and the fact that a lot of fiscal risk was backed up in the tax system. So that was one of the aims of that approach.
Well, thank you. And I think final question from Dan Carden, MP, on this subject.
Yeah, but there's also the Tax Disputes Resolution Board, and cases would be sent there if they were deemed to be sensitive. What would make a case sensitive? It is all set out in our published Code of Governance, and the Tax Disputes Resolution Board is, if you like, one level of governance below the Tax Assurance Commissioner, and indeed all cases that go to the Tax Assurance Commissioner would normally go through that board on the way, and that board would advise the Tax Assurance Commissioner what they think the right outcome should be. Broadly speaking, we use monetary limits to determine which cases go through, but we can make exceptions from those monetary limits. So we could take a case which falls below the monetary limit if we think there are sensitive issues in that case that need to be handled. That's done on a sort of case-by-case basis, and it's fairly, in my experience, sort of fairly unusual, really. But it's there in the Code of Governance if we need to use it. And would the individual's public profile or a dispute with a government minister lead to that case being deemed sensitive?
I think in my experience, the fact that someone has a public profile would not make it sensitive from a governance point of view. It's more if the nature of the dispute is something that has wider ramifications, for example, or if there is some particular issue with that that has arisen in the handling of the case that means the commissioners ought to be aware, because again there's some sort of ramification. So it's more sensitive from the tax system's point of view, I think, that we would look at it, rather than this is a high-profile person.
Thank you.
Thank you. Well, we appreciate you can't talk about an individual's tax affairs, so I think we'll leave that there for now. But thank you for putting those points on the record and answering our questions.